Good morning, good afternoon, and good evening to everyone. Thank you very much for joining us today in this webinar about the EU Omnibus package. My name is Maria van der Heijden. I am head of EU policy at ShareAction, and I will be moderating our session today. We will be presenting the implications of the Omnibus proposal that was published by the European Commission on Wednesday. We will discuss how the proposal affects corporate accountability, reporting obligations, and sustainable finance, and we will look at what the changes mean for businesses, investors, and global communities. But before we dive into the content, we will briefly share some information about next steps in the process, after which we will be hearing from our experts on the Omnibus implications for the Corporate Sustainability Reporting Directive, the Corporate Sustainability Due Diligence Directive, and the EU Taxonomy. After all 4 presentations, we will be answering questions, so please already start typing them in the Q&A chat box, which you can find at the bottom of your screen. Also, please do note that we will be sharing the slide deck. So if we will not be able to answer your question, feel free to reach us out and you will find our email addresses in the slide deck. Next slide, please. We will now go through a quick overview of the next steps in the process. So the EU Commission proposals on CSRD and CSDDD will now be discussed in the European Parliament and at member state level. A dedicated council working party has been set up at member state level to discuss the proposal, and we expect the council to go quite fast and develop their position before summer. The European Parliament may take a little bit more time because they first need to decide on the involved committees and appoint leads in different political groups. The EU Commission also proposed a stop the clock for CSRD and CSDDD implementation to delay CSRD application for companies that have not yet started reporting, and to postpone the transposition deadline and the first wave of application of CSDDD by 1 year to 2028. The EU Commission wants to fast-track the adoption of this proposal. For the EU taxonomy, changes at technical level, there is a consultation open now for 4 weeks. Afterwards, the proposal is to be scrutinized by the European Parliament and the Council. The revision of the European Sustainability Reporting Standards, or ESRS, will only happen after adoption of the Omnibus proposal on CSRD. All right, let's keep it there for process, and let's now jump to content. We will turn to Richard Gardner now, Head of Public Policy at the World Benchmarking Alliance, to speak about CSDDD.
Thank you, Maria, and thank you everyone for joining us today. It's good to see such interest in the topic so quickly after the proposal. We have a number of presentations, but over the next 7 to 8 minutes, I'm going to touch on what has been in the Omnibus proposal with regards to 2 specific issues within the CSDDD, the Corporate Sustainability Due Diligence Directive. One of those is looking at the value chain due diligence obligations, and the second will be looking at the transition plans and the obligation to implement and introduce these. So taking first the value chain due diligence obligations, there's quite a lot of detail on this slide, but it's meant to bring together the various different parts of the text that have been amended to understand the overall impact. So maybe the first thing to take a look at is what we actually were trying to do with the CSDD when we begun these discussions and when the final agreement finally came into place. And CSDD is essentially based on the UN guiding principles and the OECD guidelines of what good value chain due diligence means. And what that means in practice is that it is the obligation for a company to conduct due diligence down its entire supply chain or value chain, looking at all the activities, actors, relationships, etc., that are involved in the delivery and sale of a goods and service. It was CSDDD had some issues with whether or not it lived up to those expectations, but it did set in place a reasonable floor for companies to implement the international standards. However, what we're seeing in the Omnibus proposal is a wide-scale scaling back of those obligations. So to be quite specific, what the proposal is looking to do is narrow the definition of what value chain scope is going to be. So really taking it from a broad interpretation in line with international standards to stating that the main legal obligation will be for companies to do due diligence only on tier one, their direct suppliers. Their only obligation will be to go further than this will be when they have a complaint or a reasonable piece of information is made available by media or NGOs. So in effect, making NGOs, media, third parties a kind of enforcer of the due diligence obligation. Alongside that, the due diligence duty itself will no longer be what we would consider an ongoing process. So something that is reviewed quite periodically, every 12 months, etc. It's now something that will only need to be, the effectiveness will only need to be reviewed every 5 years. So when new issues, new problems comes up, there is some wording in there that the company will need to look at it, but no actual obligation to review whether or not the due diligence in place is effective and in line with the goals of the legislation. And then also there was quite hotly debated during the initial round around the termination of contracts. That has been replaced with a suspension. So really the kind of the piece of last resort from companies about terminating contracts, that has been taken away, and companies can in effect keep engaging in risky supply chains, even if they have no leverage, with little consequence in terms of whether or not they need to actually terminate or move away from something. Maybe in the last 2 points to tie it together, a big part of due diligence is stakeholder engagement. This is seen as a massive risk management tool. It is narrowing who are considered to be stakeholders in two ways. One, by narrowing it to those that are considered relevant by the company. So difficult to understand how that will be defined. And secondly, if you consider that due diligence itself is limited to tier one, and most of the impacted stakeholders are much further down the supply chain, will those stakeholders actually be engaged with? Will actually the real information come to light? It seems to be just a narrowing of that in general. And then the final point is the legal harmonization proposal within the text. Reminding ourselves, CSDD was always introduced as a floor, something to build on, something to go further. However, what is being proposed is actually to give a ceiling. So not only reducing the overall value chain due diligence obligations, but ensuring that there is no way for member states to introduce further rules, therefore leaving no incentive for companies to go further than what's in the text. Next slide, please. Just to visualize specifically on the tier one versus the entire value chain due diligence, which kind of make it seem more real. This is basically where we see how the OECD and UNGPs intended for the entire value chain to be covered. CSDD introduced the definition of chain of activities, which broke the value chain into upstream and downstream. Again, there were certain issues with that, but by and large, it did go a sufficient way down the value chain to build a floor on that companies could improve their performance. However, what we're having now introduced is essentially a legalized narrowing of this only to direct suppliers, and additionally, as you see here, no obligation to do due diligence on those direct suppliers who have less than 500 employees. And this is an issue where it's about reducing the burden on SMEs, but actually would mean reducing the amount of due diligence that has to be done by companies if they cannot get information. So this to us is quite a worrying development about the overall effectiveness of addressing the human rights and environmental risks in supply chains. Next slide, please. This moves to the second part of what I would like to present around the climate transition plans on Article 22. Again, this was hotly debated at the time and continued to be. The final text introduced was significant because it talked about adopting and putting into effect a transition plan for climate change. Those 4 words are quite significant. And of course, we're now delving into the detail of this and what this means for further legislation, etc. But the initial reading is by taking out this obligation to put into effect a transition plan, it is greatly watering down the impact that this article was intended to have. I understand the Commission have said that they are trying to maintain the Green Deal, and there was a lot of discussion internally to make sure Article 22 wasn't scrapped completely, because there were proposals on the table for this. But where they have landed is kind of a halfway house that still reduces the impact this is going to have. And it reduces it for 4 reasons. Essentially, by removing put into effect, the big value of CSDD was to add a behavioral element to what we have in CSRD around an assessment and disclosure element. The put into effect was that behavior element. It would actually shift companies' attitude to not just designing and putting in place knowledge of a transition plan, but actually having it work, assessing whether it works, having other external forces able to scrutinize whether this plan works. This in turn reduces accountability. So if there's no obligation to actually adopt and put into effect a transition plan, how can outside groups, rating rating agencies, investors, stakeholders actually assess whether or not this plan is credible and works. In terms of creating potential legal loopholes, if this gets interpreted to be reduced to just having a policy in place, well, then what is the ability to actually introduce penalties if the climate plans are not working, if they're not in line with the legislation? And there'll be more on penalties next. But that is also a big concern. And also regulatory inconsistency with the EU climate law and other intentional laws around this, where the logic was member states introducing measures to put into effect plans for a transition to a decarbonized economy. Again, this goes against that. This goes completely against that intention, and worst case scenario could reduce these plans to kind of a paper exercise, a publicity exercise, but something that doesn't have any real impact in how the company functions. And I can stop there, Maria. I'm happy to pass back to you.
Thank you very much, Richard. Just as a reminder, I see quite a few questions about the slide deck and the recording. Yes, they will be shared afterwards. And please keep sharing all your questions, which we will answer after all the presentations. I will now hand over the floor to Marion Lupin, Policy Officer at the European Coalition for Corporate Justice, ECCJ, to present the proposed changes on penalties and civil liability in CSDDD.
Thank you, Maria. Thank you so much to the colleagues for having me. We can dive right into what is indubitably one of the most significant changes from this Omnibus proposal, which starts with the question of civil liability and indeed the deletion of the EU-wide civil liability provision. In concrete terms, this means that the CSDDD as it stands and as it is currently into effect requires every member state to make sure that companies can be held civilly liable when they fail to comply with their obligations under the directive. While this change would entail that it is left up to either existing national law or the possibility for each member state to introduce specific clauses of liability that have to do with the implementation of the due diligence obligation. This is, in our view, a clear step back from harmonization and avoiding fragmentation of the EU market because, and I really want to stress this, the deletion of the civil liability clause does not mean that there can't be civil liability and that companies may not be held liable. It just means that it will be up for every member state, every jurisdiction to determine based on their existing law or based on transposition whether or not there should be civil liability in the context of due diligence. In turn, for victims, this means that there is an increased, almost sole reliance on national legislation, which we know in practice from past cases recurrently fails to hold companies accountable. Most notably, and this is just two examples that I've put in there, but there are many more, in cases that involve corporate groups, because most often the liability is limited in case of where the damage is caused, created, contributed to by a subsidiary. It is very difficult to then hold the parent company liable. And also in the case of complex value chains, because existing national legislation that is not meant to deal with these extraterritorial cases, so to say, provides an added layer of complexity when it comes to determining the liability of subcontracting relationships. As an overall comment, of course, this is a major loss in terms of enforceability of the directive, because it's worth bearing in mind that the CSDD was originally conceived with a two-pronged approach for liability, one being civil liability in front of the courts and one being administrative liability in front of administrative authorities set up in each member state. Next slide, please. In terms of also that relate to civil liability in a broader sense, We also see the deletion of the overriding mandatory provision. Now, this is a term that won't mean much to those who are not lawyers in the room, but in very simple terms, it means that, again, the CSDDD as it currently stands requires that the European legislation is of overriding mandatory application, meaning that judges should make sure to apply it to the cases that come before them, even in case the general rules would say that another legislation is of application. This deletion, it sounds very boring and technical, I'm very aware, but it can lead to very practical and very tangible consequences, such as a national EU judge, let's assume in Germany, might be led to apply and required to interpret legislation of a country that it's not their own. And that is most often going to be the law of where the damage happened. So we might have, against this is a hypothetical, but a case where a German judge might be required to interpret and apply and make a decision based on Bangladeshi law, which of course it's not ideal in terms of legal certainty and predictability. In terms of access to justice, because unfortunately access to justice is also the target of some changes by this omnibus proposal, we have the deletion of the obligation to provide a representative mechanism, meaning that member states will no longer be required by the directive to ensure that NGOs, trade unions, national human rights institutions can legally represent victims in court where these victims might not have sufficient means to represent themselves or seek independent legal representation, which of course is a major barrier in our opinion to the effective ability for victims to seek justice and obtain full compensation. And then you'll find at the bottom a note that said that for those of you who have been following the omnibus a little too closely, you might remember that there were some leaks at the beginning of this week that hinted also at a reduction of the mandatory minimum statutory of limitation to introduce claims, but this fortunately has not been taken up by the final proposal. And then next slide to wrap up. There's also some changes in terms of penalties. So we are now moving to the administrative liability side of enforcement, no longer civil liability. There's quite some significant changes here too, in terms of there will no longer, the penalties that can be applied by member states will no longer need to be based on global turnover, but might take into consideration other criterion. And then the most significant change here is the removal of the maximum cap for penalties, meaning that while right now member states could not set a cap for penalties that is below 5% of the company's global turnover, this is removed. A lot of discretion is given to member states in terms of where to set this threshold for penalties, which of course raises concerns of race to the bottom dumping, where member states will be incentivized to set as low penalties as possible in order to maintain their attractiveness for businesses that might be domiciled there. And again, just as a final remark, also a step away from harmonization and avoiding fragmentation. I'll leave it here and hand over back to you, Maria. Thank you.
Thank you very much, Marion. We will now go to Julia Otten, Senior Policy Officer at Frank Bold, to discuss CSRD.
Yes, thank you, and good morning also from my side on this Friday after a busy week. I would like to look into the major issues at stake concerning reporting together with you. I would like to start with something that has already been raised by many questions in the chat and that Maria already laid out briefly in the very beginning, which is the so-called stop the clock. I think that's a bit misleading, but the postponement or that the Commission proposed. We really have to see this as a separate directive, as the Commission intends to fast track it. So this postponement only concerns second and third wave companies, but it plays out very differently for CSRD, of course, compared to what we see on CSDDD as a postponement, because the majority of the EU member states have already transposed the CSRD. We already see in the last couple of days it has created quite some confusion for first wage companies as well in terms of what's applicable to them. So just to share our very general advice at this stage, not knowing how long the political processes take is really to keep using the ESRS framework and to focus on its strategic elements, such as Commissioner Albuquerque also referred to on Wednesday in the presentation. So the double materiality assessment, etc., so that you're not surprised by any of the political final outcomes and you comply with what has already been transposed. I know this is unfortunate and creates confusion, but maybe we can dive into follow-up questions later. So there's this pink line just to distinguish on level 1 changes that regard to content. We really have to separately look at what the Commission proposed on its scope, limiting it to the very large companies with more than 1,000 employees. This is really limiting the mandatory requirements to report to, and it's reducing the scope by about 80%. That's a big carve out to who is actually complying now and who has previously complied also with the NFRD, so the previous legislation. We are particularly concerned about this complete removal of mid-cap companies without giving them a proportionate standard, because it's also in direct contrast in terms of what has been voiced previously by, for instance, the Draghi report, but also by governments from France, Italy, and Spain. And the concern is that just the reliability and the availability of the sustainability data will be drastically reduced. Turning to the second big issue, the value chain cap, which is something that has already been in the CSRD before, but it's now connected to this newly proposed scope. It basically means that you're limiting, or the Commission is proposing to limit the information that companies can ask their suppliers outside of CSRD scope to what is actually specified in the voluntary standards. So we have a concern with how this is phrased, because we need to remember that the voluntary standard, or the VSME, is really written or was written originally for very small companies. So from our perspective, there are some adjustments needed here. If we look at assurance, the Commission proposes to cross out the shift to reasonable assurance, so keeping it to limited assurance, and also wants to issue targeted assurance guidelines by 2026. Now, guidelines from our perspective are really crucial, and they are needed as soon as possible in terms of what we see in practice. Next slide, please. If we look at the changes that the Commission proposes to the level 2, so the standards itself, I'd like to begin with the ESRS set 1 itself, where the Commission announced a reduction of data points, particularly on the narrative data points. I think there is quite some stakeholder agreement that we can and need to talk about the granularity of the data, but this should not put at risk the key data, particularly on the social standards that cannot always rely on quantitative data points. And the intention is to publish those again at the latest 6 months after the entry into force of those level 1 changes on the Omnibus. As concerns sector-specific standards, the Commission basically deleted its power to adopt those, which is basically deleting the sector-specific standards. Now, this leaves, or the Commission or the EU basically gives away its own power to actually clarify the sector-specific approach, so what data it wants from high-risk industries. And this we will see these standards being shaped by the international standards, so by ISSB and SOSB, and we think that's unfortunate to give away for the EU. If we look at the voluntary SME standards, the Commission now also proposes to issue a recommendation quickly in terms of these voluntary standards and to adopt the VSME as a delegated act. As I said, we think it has to undergo some clarification on language because of its new use that is foreseen. And if I may, I'd like to wrap up with 2 main suggestions on the next slide, which is on the one hand that we do think it's very crucial to now discuss what mid-caps actually need. And from our perspective, there is a clear need to give them a proportionate and clear standards, because carving them out just from the mandatory regime really risks that larger companies don't have the accessible, reliable data that we need to get something out of this. And from our perspective, the VSME is not fully fit for purpose for this. Now, secondly, we do see in practice that sector-specific guidance, and I'm talking about guidance, not about standards here, really can provide support if it's targeted, focused, and doesn't add to the data points, but it can clarify the materiality assessment for companies. It can help them to get their filter right and prioritize really the most important sectoral matters, both concerning the transition, but also concerning systemic human rights issues in global value chains. I look forward to your questions, and I'm happy with that to hand back over to Maria.
Thank you very much, Julia. So finally, let's move to Mariana Ferreira, Sustainable Finance Policy Officer at WWF, to speak about the EU taxonomy.
Thank you very much, Maria. Good morning, good afternoon, everyone who's following us. So I'll briefly introduce the technical changes to the taxonomy, but mostly focus on its implementation consequences. So firstly, the changes proposed were kept to level 2 amendments. So currently what's on the table being discussed, it's the Disclosures Delegated Act. And in the future, we will also see changes to the Environmental Delegated Act. More concrete proposals and specifications will be needed to clarify how the Commission aims to implement some of the proposals that were brought to the table, namely how changes to the do no significant harm criteria will be made from the perspective of simplifying, how the streamlining of substantial contribution criteria will be carried forward, given that we do not have the templates currently available on the Commission's website, and making concrete meaning of what partial alignment will look like on legal terms and per definition. If we can move to the next slide, Maria. So under the taxonomy, the main changes proposed by the European Commission firstly concern the scope that the law will cover. There will be a reduction of the scope by 85%, meaning that 85% of the companies will not have to report on a compulsory form under the taxonomy. This will mean that it will only apply to companies above 1,000 employees and with a net turnover of more than 450 million euros. The second major proposal is to add a materiality threshold of 10% and 25% for reporting under the taxonomy. This means that companies will not have to report on activities that represent less than 10% of their revenues and capital, and less than 25% of their operational expenditures. For financial institutions, this means that they do not have to report on 10% of their assets, meaning their loans and investments. The concept of a materiality threshold per se was advocated for in the past by the platform on sustainable finance, and it's not problematic, but the current threshold of 10% is significantly disproportional, considering that the scope was reduced to the largest companies. So 10% of the largest companies' revenues and capital is massive. And these will be data which we will not have access to, and with less availability of data, there is less comparability, and this will impair the effectiveness of the taxonomy in the EU's transitioning efforts. So these two measures combined, the reduction of the scope and the new materiality thresholds, represent a significant butchering of the EU taxonomy framework after 3 years of companies and financial institutions reporting, and only showcase the devastating blow to the Green Deal that this Omnibus proposal represents. They also risk and threaten the Green Bonds Initiative, which depends on the availability of taxonomy-related data. The third major change relates to the exclusion of companies from, apologies, for the opt-in regime for OPEX, which means that companies will report voluntarily on the OPEX and not on a compulsory regime. And fourthly, now, the exclusion of undertakings outside of the scope of the taxonomy from the green asset ratio denominator. This will result in an inflated ratio, because the lower the denominator, the higher is the outcome of this formula. And this is of particular concern to us, because this will allow or this will result in companies not providing a truthful and clear value on their transitioning efforts and performance. On the realm of the do no significant harm principle, the Commission has presented that they wish to do a further revision and streamlining, which will come in the future, but currently the pollution criteria has been subject to major simplifications. There is also the introduction of the concept of partial alignment, which was not possible in the past. We don't know concretely how this will be made in practice, and what does it mean from a legal standpoint. We recommend that the European Commission takes the proposal from the platform on sustainable finance, which establishes a three-colored approach, green, orange, and red, where the orange depends on compliance with the do no significant harm criteria. And finally, there will be a change in the reporting templates. We do not have access to the templates yet, so yet to be seen. To come, as I mentioned, a future review of the green asset ratio, a further future review of the green asset ratio, and a wider revision of the technical screening criteria, meaning the do no significant harm criteria, but also apologies, the significant impact criteria. Maria, if we can move forward. So, as a final analysis and on a few notes, these two measures combined that I mentioned, the reduction of the scope and the new materiality threshold, are threatening the objectives of the taxonomy and might contribute towards making the efforts of companies who are reporting a ticking box exercise. Because as there is less information available and there's less comparability, this will reduce the meaningfulness of the information being published. As a way forward, the European Commission should make available the criteria for a wider number of eligible activities, which will allow for a playing level field and allow for companies who are making efforts towards transitioning to showcase their transitioning performance. This has also been asked by the past years by different stakeholders, including major companies. On a last note, the taxonomy did not escape the disastrous backtrack on environmental commitments that we witnessed on Wednesday, despite the changes being limited to level 2. What we are witnessing is not only a blow on the Green Deal, but a blow on the credibility of the European Commission itself, which for years pushed companies into investing in preparedness and compliance with this framework, and now is doing a U-turn. It is now essential that moving forward, the European Parliament and the Council ensure a more structured and evidence-based approach, and that any further discussions and proposals brought forward are fact-based. Thank you, Maria. This is all from my side.
Thank you very much, Mariana, and also thank you to the audience for all the appreciation expressed by the emojis Much appreciated. All right, we have about 25 minutes left to go through questions. We have been receiving a lot, where each and everyone is trying to respond to them in the Q&A as we go. Yeah, they're quite a lot. So bear with us, because we have over 130 questions that are not yet answered. But do please keep them coming, because we will have access to the questions later on, and we will try to group them as much as possible. I will start with a question now on double materiality. There have been some rumors that double materiality might be scrapped by the Omnibus due to pushing some businesses, which has not materialized in the end. How much of a relief is this, and why? Julia, are you happy to come in on that?
Yes, very much. Thank you for the question. Materiality and double materiality really is at the core of the sustainability reporting. And I think we can also see this very clearly when we look at how companies are actually assessing their impacts, not just from a financial perspective. If you really want to look at risks and impacts, you need a system to grasp these, also to see how they financially play out. So it's a very core element, where also in terms of what's happening in the Asian markets, we are happy that the EU kept its leadership on this core element. Thank you.
Thanks. And maybe, Julia, if we can stay with you a little bit, because there are a lot of questions about the stop the clock, and what companies should do, companies in wave 2 and 3 should do now. I know that was covered in your presentation, but maybe you can expand on that a little bit.
Yes, as I said, I find the wording "stop the clock" a bit confusing for CSRD companies, or for those who have to comply, sorry, with CSRD. So our general advice, both for the first wave that are already complying, as for the second and third wave that are subject to this postponement, is that you really keep moving forward using the ESRS framework, focusing on the strategic elements for you. So that is double materiality assessment, gap analysis, etc., and that you're not surprised by any political outcome, because this will take some time for the co-legislators to agree upon, and you have national laws in place that you have to comply with in the meantime. I'm sorry, otherwise, please raise this concern also with the Commission and the co-legislator again. Thank you.
Thanks, Julia. And that actually segues nice into the next question, or next questions, because we have received a lot of questions on strategy. What to do now? How can this proposal still be influenced? Richard, would you like to come in on that?
Thanks, Maria. Happy to give it a go. I think to build on what was introduced at the start and through the various presentations, just practically speaking now, by reopening the text legally, the proposal now goes to both the European Parliament and European Council for consideration and discussion, which means we're going back to the exact same process that designed CSDDD to begin with 3 or 4 years ago. So essentially, everything is now back on the table, both the proposals made by the Commission and also those aspects of the text that haven't been touched by the Commission. So it really is, while it's claimed to be a simplification, a targeting opening, it is essentially opening up everything in level 1 of both texts again. And so what we will need to understand is, what is the political interest to change the text in whichever way. So there are many that we know that don't like these changes, that would like to remove them to go back to the original text. We also know there is quite a significant group that want to actually further water it down, perhaps even remove it completely, etc. And so this is the kind of area we're looking at now. Without going into detailed strategy, 3 days after the proposal, what we can say is that we would encourage everybody who has an interest in this to try and understand themselves what are the key risks for them, and to start formulating them, and either through reaching out to us or through your national groups or whatever, to start making those voices and opinions heard towards, if you have MEPs in your jurisdiction, member state governments, or to the Commission, because we are now going back into that cycle again. And this is most likely going to continue, probably, I would say, and I'm just speculating here, on the fine detail for at least 6 months to a year, given that there is no agreement on what the ideal outcome is with the political makeup we have at the moment. So yeah, it's very much all to play for, and really would encourage people to start making their voices heard and to push for positions that are a position that they want based on what their reading is.
Thanks, Richard, and bringing in Marion as well to talk a bit about strategy and the likelihood of this getting passed.
Thank you, Maria. So obviously the answer at this stage is it's all speculation because it depends on a lot of factors. But I do think it's worth reminding and having in mind that this is quite unprecedented time, I would say, in EU lawmaking. We've seen the Commission approaching this whole Omnibus initiative in a way that is, let's say, that doesn't exactly reflect the way that EU legislative proposals are usually put forward. And that this also comes in a moment of geopolitical international relations that are quite tense. My point being, we might see a procedure that develops in an unusual way. So, for example, while in Council, because as a reminder for those who are not super familiar with the EU legislative process, both Council and Parliament will need to reach their own position on this proposal, and afterwards will need to move into a trilogue, another phase of negotiations where they reach a compromise between those two positions. And while we do see the possibility of Council coming to an agreement quite quickly on what they would like to see reflected in the final proposal, the Parliament, after the last elections, looks quite different than it has in the past. And we have some sort of various possible majorities, some of which include the progressive and are where the progressives are needed to pass legislation. Some of them that would be possible with the configuration of conservative with the groups to the broader right of the political spectrum. So I know this is not a very satisfactory answer, but right now it's quite difficult to assess, and we are foreseeing quite a bit of negotiations from quite a bit of different sides of the aisle. So just to say, this will, this could take a while.
Thank you very much, Marion. There was also a follow-up question on the removal of EU-wide civil liability and whether there are any countries where there will still be de facto civil liability. Could you comment on that?
Yeah, I think it's a very interesting question because it's really important for companies, for lawyers, for stakeholders to understand removing the EU-wide civil liability clause is not akin of saying companies will not be held liable anywhere in Europe for these when it comes to matters of due diligence. It simply means that the question is left up to national governments, meaning that in countries where the general law of tort right now would allow to bring cases against company in asking for them to be held liable, that would continue. The fact that there is no EU-wide clause does not change the existing legislation at national level, just as much as countries which, for whatever reason, where it's not possible to hold companies liable right now, but they would like to introduce it as part of their transposition of the directive, there's nothing stopping them either. So really, in much simpler terms, when we ask what is the consequence of removing the EU-wide liability clause, it simply means that companies, in theory, might need to make 27 different assessments for 27 different countries of whether or not the law of that European country would allow to hold them liable under specific circumstances. So it kind of complicates the picture more than simplifying it.
Thank you very much, Marion. We are also receiving a lot of questions on the taxonomy. So I'd like to bring in Mariana here to address some questions around scope and the cut of 80% of companies, and for instance also the optional taxonomy reporting and the opting in Mariana, over to you.
Yes, so can you please read the question you're referring to?
Sorry, I was trying to bring in a couple, but let me go one by one. So regarding the taxonomy, companies in scope of the taxonomy are the new scope of CSRD, which cuts about 80% of companies. For the CSRD, the reduced scope certainly means less visibility, but what is the impact for taxonomy? Larger companies are making larger investments. Do we know how significantly the scope cut affects our visibility on sustainable investments? Let's start with that one.
Yes, definitely. In fact, there is a report from the Platform on Sustainable Finance from 2022, where they showcase how the 10% threshold, just talking of the threshold here, will exclude more than 40% of the companies under the NFRD from reporting on RevX, so their sustainable activities against their revenue, for example. And this would be for the 15% that are left within the scope of the taxonomy. So as I mentioned, the reduction of the scope and this new materiality threshold will result in a massive cutting of information available and a lack of comparability. These will impair completely the ability of the taxonomy to deliver. In fact, the beauty of the taxonomy is to present a simplified framework for comparing information from the perspective of sustainability. If less information is available, there's less comparability, and thus the data that we have access is less meaningful, which also creates burden on companies because makes the exercise of reporting less impactful, less meaningful. So indeed, this is a huge blow on the taxonomy and will have a wider systemic impact.
Thank you very much. There continue to be a lot of questions on CSRD scope application, but maybe we will bring in Julia first on the impact of to non-EU companies.
Yeah, if you read the both postponement, but also the proposed changes on the scope, and again, really important to distinguish between the two, they concern the overall scope, so including non-European companies, of course. So there is no separate distinction between how this is applied to EU or non-EU companies. So it generally applies to the non-EU companies in the same way.
Thank you very much. There are also questions about transposition and what it means for countries that haven't transposed yet. To Julia, sorry.
That's a good question. I think we have already seen a couple of countries coming out on the member state side that have transposed CSRD with strong voices and strong recommendations of how they want to see this process moving forward. I think it's going to be an interesting discussion to watch in the council. I cannot fully answer the question for every single member state at this stage because yeah, that's simply a bit too early, I think. Yeah, but I'll leave it at that. I think this is something we really closely have to watch in the council discussions.
Thank you very much, Julia. There are some questions also on what it means for the financial sector, specifically, for instance, what will the Omnibus proposal mean for CSRD reporting on financial climate risks? Richard, would you like to come in on this, the data availability and what that means for the financial sector?
Sure, happy to. And actually, you've seen some public reactions already from trade associations representing banks and investors. What the immediate reading we have, just very bluntly, from a huge reduction of predictable reports that will be made available by companies, an 80% reduction of that means that for the banking sector, for the investment sector, they are facing further uncertainty as to how they will gather information around companies' plans for a green transition, for dealing with social issues, etc., etc. And so therefore their ability as a financial sector to deliver on financing the Green Deal, Sustainable Finance Action Plan, etc., is essentially greatly hindered because of that. And you could potentially also see further knock-on effects for what you would possibly have, most likely coming from ESG rating agencies, other such tracking and indexing tools, etc. All of these set up to rely on data, and all of them basically being designed in line with the ESRS indicators, both the financial materiality and the other materiality aspect, to then package them in a way that are useful for the financial sector depending on the portfolio they have, the sectors they're involved in, etc. So there's a real contradiction from the Commission by reducing the amount of data that's going to be available, while at the same time saying that Europe needs to basically free up the savings that we have in our bank accounts, which is kind of how the European market works, and put it into sustainable investments. Two things cannot be true at once, because really going from 50, 60,000 companies that would have to be much more transparent in a more predictable way to about 7,000 does not give the intermediaries, brokers, banks, etc., the ability to actually take our savings, if you're based in Europe, and put it into sustainable portfolios, because the information will not be there. And even maybe one more point that was made at the press conference by the commissioner was they expect a large amount of companies not directly in scope to still report in line based on market demand. I think we would be quite skeptical just based on historical evidence about that. But even if there is some sort of uptick, it will not be done in a comparable and predictable way. So you will still get a situation where it could be comparing apples to oranges, even within companies within the same sector, because they are not held to the same level of scrutiny, or they will not be guaranteed to be using the same reporting templates, etc. So really what investors and banks have always been saying is they want a predictability, credibility, and comparability between the data. Under the current proposal, that just simply isn't there.
Thank you very much, Richard. Bringing Mariana back in to address some additional questions on the taxonomy.
Yes, indeed. I saw there was a question from someone regarding voluntary reporting. And yes, voluntary reporting is always encouraged. The only issue you might face is that the activity your company is invested in is not eligible. So this is why it's so important for the Commission to publish the criteria for more eligible activities. And we know that the EU Platform on Sustainable Finance has drafted this criteria, and they are sitting in Albuquerque's desk at this moment. So maybe this public consultation that follows the Disclosures Delegated Act will be a great opportunity to ask for the Commission to publish these very important criteria in establishing a playing level field, ensuring that companies have the opportunity to showcase their transitioning performance. On how will investors judge if an activity is sustainable? This is a great question, also one that we can address to the European Commission. And this is where the risk lays. This is where the risk of lack of data impairing our ability to rechannel capital and funds into sustainable activities. So I urge you all to participate in the public consultation and bring all these thoughts and concerns to the table.
Thank you very much, Mariana. There are some questions on follow-up questions on strategy. So what are best ways to show the Commission we are not happy with the Omnibus? Is there an open letter or an email we can share? But then also more specifically, what's the most effective way for rights holders from the Global South to make their voices heard on the consequences of these changes? Marion, are you happy to come in on that?
Yes, that's a very good question, one that we like to hear. The answer is lots. A lot also depends on what kind of stakeholder is asking this. For example, we on the side of civil society, we are preparing a joint statement addressed to the Commission to express our deep concerns at the extent of this proposal. I have excellent colleagues that work a lot on business engagement. So in case that question is coming from a company, please know that there are people out there that very much are looking to coordinate a company's response to the uncertainty that these changes are creating. In terms of Global South and Global South rights holders making their voices heard, one way to to carry your voices directly here in Brussels is, of course, to get in touch with civil society organizations that work here and have been involved in the Omnibus. But if there's one big lesson learned, I would say, from this whole Omnibus process, especially on the CSDD, I dare say, is that third countries and their position, their opinion of European legislation that has extraterritorial effects is very much something that the Commission cares about. We have seen it now twice in a row with the deforestation regulation and now with this Omnibus, where concerns expressed by foreign governments towards the Commission on EU legislation led the Commission to take those concerns very seriously. I think there is an aspect that we shouldn't underestimate of speak to your government. You are the most directly affected by these changes. Your government is supposed to care, and your government is in a good place to carry your voices also towards the European Union, in saying that, simplification is not always the most desirable goal in some.
Thank you very much, Marion. There are questions about what this means of the lowering of the standards in relation to the OECD and the UN guiding principles on business and human rights. Richard, would you like to comment on that?
Thanks, Maria. Yes, just briefly, and linking it to the first slide I shared, the real concern overall when you look at these proposals, and I think as well across both the reporting side and the due diligence side, is that they are much lower and not in line with international standards, which means that, to maybe people on the call who've been working on UNGPs way back in the middle of the 2000s, and then when they were agreed in 2010, the OECD guidance has been developed since then and also has both a general guidance on due diligence and one for multinational enterprise, as well as specific sectoral guidance. So all the advances that have been made, CSDD was kind of the next step in that journey. What's currently on the table actually ignores all the advances and progress that have been made and would introduce potentially a legal ceiling that is lower than current international standards and very worryingly lower than what large companies and big companies that have recognized their risks and are involved in risky sectors are actually doing. So we could be legally lowering the bar from like instead of adding to the general journey of corporate sustainability, actually legally lowering the bar and potentially even calling into a question how we advance what we've done with the UNGPs and how we advance where the OECD is, etc. Because there could be a legal limit to what companies actually have to do. And that's what's quite concerning. When you add up all the little pieces, you see how it might work in practice. And then when you add potentially a legal ceiling on top of going further, what does that mean for the kind of global project around corporate due diligence, corporate sustainability? So again, I think something to add to the messaging, like what Marianne was saying about how important this discussion is beyond some of the detail. There's a broader context of what is at play.
Thank you very much, Richard. Also, just to remind people, I see a lot of questions on that. Yes, we will share the slides, and we also, in which you will be able to find our email addresses, and we will also share the recording. All right, we have a couple of minutes left, so we're slowly wrapping up, but we will do some last questions still. There continue to be questions on CSRD Wave 2 and Wave 3. Julia, I know that you have come in on that already, but there are still a lot there. So if you would like to take the floor on that still, specifically whether it will be limited to companies with more than 1,000 employees, is there anything you would like to add?
Yeah, to be very honest, I'm having troubles to follow all the questions because there is so many of them. So if you can point me to the very specific one about, and so that I can really add something to what I already said before. Maria, do you have it in front of you?
Would the future CSRD wave 2 and 3 be limited to companies with more than 1,000 employees only? And also, if the Omnibus legislation is not completed within the year, will wave 2 companies be required to fulfill their disclosure obligations under the current CSRD for the financial year 2025 period in 2026?
Yes, thank you for those questions. So very shortly on the first one, this really depends on how the discussion on scope go in the European Parliament and amongst the co-legislators in especially the Council and the Member States. As I've said, some of the Member States have come out, especially also regulators at national level, to ask for a more targeted approach. So not to mess up too much with the thresholds. So we will really have to see over the next year or so when this process goes through the council what their position is and where they will finally land in terms of scope. So I'm sorry, but it's just too early to say whether this proposal from the Commission will stand and will hold on the CSRD scope as such, because there are other interests here and proposals on the table. With regard to the second wave companies, well, that's somewhat connected to what I just said. I mean, the scope limitation is definitely intended to kick in after the postponement so that hopefully there would be clarity. This, I think, is the thinking of the Commission, to separate the two and to fast track the first one. And we will have to see if the political process can actually deliver in such time to really give clarity to wave 2 and wave 3 companies in terms of the scope and in terms of the standards as well.
Thank you very much. Finally, also some questions with regards to the value chain and risk-based approach. So how to square the limitations of 500 employees. Would you be happy to address that as well, Julia or Richard?
I can start, Richard, and feel free to jump in as well, because it's a bit of a closer connection that the Commission now proposes between CSRD and CSDDD. So I think, as Richard and I just can second and underline the concern with cutting on this risk-based approach that we originally had in the CSDDD, because there were so many lessons learned also from the German context in terms of keeping this a risk-based approach, so it is actually effective in practice in terms of addressing most severe impacts, looking at forced labor, etc., and where this is located in the value chains. Now, the Commission, with these limitation to 500 employees, limits one element of direct engagement, etc., looking towards indirect suppliers, but it also limits the approach towards smaller actors in the value chain below 500, with marrying it with this value chain cap. And we find this last element very, very problematic. On the one hand, it's not clear to us why there is a small backdoor in terms of asking for information but not disclosing it then via the CSRD. That's a strange proposal from our perspective. And secondly, in practice, if you want to really change something in terms of your severe impacts, you just need to look and discuss with your suppliers that are also smaller actors, that are more maybe in the informal economy, etc. So for the effectiveness of these laws, there is no way around a risk-based approach from our perspective.
Thank you very much, Julia. Mindful that we are already past the hour, we will do a quick round of closing comments for all speakers before we wrap up. Richard.
Thanks very much, Maria. Just picking up on the question there that Julia was answering. The real concern with how they've written this is they're trying to take a position of we need to reduce the burden on SMEs, small companies, and that size differs. But the reality is actually, if you read CSDD and how it was originally phrased, it really put a huge emphasis on the responsibility being with the large multinational that was in scope, and that at every stage their engagement down the value chain needed to be an engagement also in terms of time, resources, technology, etc., collective engagements, not just single companies, but sectors coming together, etc., in order to not pass the burden down the value chain, but to properly engage to understand what was happening. So it was written very much from a risk-based approach. Also, there was no expectation that under CSD that companies would have to do the same level of due diligence through down every single supply chain that they had. They had to basically identify where their risks were their most salient. They could prioritize those risks as long as they justified it and made information available, and then do that. It essentially would have been less burdensome than what is currently being proposed, because what is currently being proposed is that every single tier one relationship you have to engage with, which means at a minimum you have to in some way have contact with them. And so companies have long complained, oh, we've got 200,000, 300,000, these big figures out there of suppliers. Well, now, based on what's happening with this proposal, you legally have to interact with all of those. Under CSDD, the original agreement, you didn't. You had to do a risk assessment and do it like that. And then maybe finally just to say is that on there was a question on contractual cascading. That's quite worrisome as well when you think about the practicalities of essentially the current proposal pushes companies in scope to write very firmly in their contracts the expectations they have with that tier one supplier, which will then make the tier one supplier write that into the tier two contract, into tier three, tier four, etc., with no control or no leverage or no interaction with the main company that's in scope of CSDD, no way to see to what extent that evolves, changes. It essentially could create a massive chain reaction of increasing burden as everyone tries to protect themselves from some sort of risk or some sort of issue. So again, there's no engagement within that. You're just writing things, essentially forbidding practice through contracts. So that is quite worrisome at the moment. So I think for maybe any companies listening or those small scale suppliers, highlighting those kind of issues would be really the practical issues that would be really vital at this time. Thanks, Maria.
Thanks, Richard. Marion, your closing comments.
Thank you, Maria. I'll very much echo what Richard said. We really push back against the narrative that this proposal brings simplification for companies, not only because of the risk-based approach concerns that Richard just raised, but also in terms of enforcement and sanction. I've said it before and I'll say it again. There's nothing simpler in asking companies or expecting companies to navigate 27 different legal systems where rules and basis for their liability or lack thereof might look slightly different depending on a lot of different criteria. Just like there's nothing that brings simplification in saying that there shouldn't be a common minimum for pecuniary sanctions to avoid a race to the bottom and dumping of standards across jurisdictions. So if I can make a little bit more of a political point here, the Commission has been very strong and firm in saying that this is not deregulation, it's to alleviate burden on companies. First of all, again, I echo what Richard said. We very much do see a responsibility within member states to alleviate burden on SMEs, and it's not by scrapping the obligations at the top that you necessarily alleviate the obligations at the bottom. But also, again, if this is not deregulation, then why removing or why weakening crucial instruments of accountability if it's not to tell companies that, yeah, you don't really have to worry about it so much. Even though, again, I'll say it, liability is still very much on the table across jurisdictions. It's just going to be, instead of something that can be determined at EU level, it's something that is going to have as many answers as there are legal systems and cases. So legal uncertainty and all of that. Thank you, Maria.
Thank you very much, Marion. Over to Julia.
I'll try to be really brief. Just a short comment, maybe to add a bit in terms of how the EU is being looked at globally with these current proposal. I think I'd just like to issue a call that we have to be really careful, and the EU has to be really careful how other member states will read this, and they're clearly watching this space. We see how Russia and China and the US have positioned are positioning themselves. So to base this on very concrete evidence, we want to see for any change that is coming out of this process that we have clear evidence on the table of why it is needed to really avoid a plain race to the bottom in global value chains. Thank you. Back to you, Maria.
Thank you very much, Julia. Mariana.
Thank you. I undersign to everything that what's been said. Maybe I can add that at this point, there's nothing rational about the discussion around the omnibus proposals. So if you are confused, that's not on you, because it's becoming more of a political discussion. The Commission, in less than 3 months, has butchered legislations that took almost a decade of impact assessment, stakeholder consultation, and proper studies to be developed. This is creating unprecedented regulatory uncertainty and volatility, both for companies and investors. And what we need as a way forward is to refocus the discussion on the rationality, on the causes that brought us to have this legislation in the first place, and to ensure a more structured, a more evidence-based approach.
Thank you very much, Mariana, for that reminder. Really a key message there. I will need to call it a close. I would like to thank everyone for joining us today. It was great to see so many of you join and your interest. We are aware that we have not been able to address all your questions. We apologize for that. But as mentioned, please do get in touch with us via the email addresses that we have provided. And also please continue to stay involved in these conversations and use any influence that you may have to try to still have an influence on this process. Thank you very much. All have a lovely rest of the day.